7. Taxation. A. In general. Section 83. Generally. The motive in forming a business trust is generally not considered by the courts in determining its validity, and it has been held that a business trust is not rendered illegal because of the fact that it was formed for the express purpose of reducing or avoiding taxation. But although the business trust once enjoyed certain tax advantages as compared to corporations, a factor which contributed largely to the rapid spread of this organization as a vehicle of commercial endeavor, the general trend of legislation in recent years has been to minimize or remove entirely any such advantage inherent in the business trust. A significant exception to this trend has been the enactment, in 1960, of certain sections of the Internal Revenue Code, entitled Real Estate Investment Trusts, which may well result in renewed interest in the business trust, because of income tax advantages offered to shareholders in associations of this nature which invest in real estate and choose to qualify under the Act. In some states where the use of the business trust has been restricted or precluded, legislation has been adopted or proposed to enable such associations to take advantage of the tax-saving features of these federal statutes. Section 84. Taxation as partnership or corporation, generally. Where, because of the power control vested in the shareholder, a business trust is in legal contemplation a partnership, its property has been held to be taxable according to the statute relating to the taxation of the property of partnerships. However, where the title to trust property and the exclusive management of its business are vested in trustees, free from any control by the shareholders, and the rights of shareholders are limited to each receiving his share of the profits during the continuation of the trust, and of the corpus upon the termination of the trust, the organization is held to be a true trust, and not to be taxable as a partnership under such a tax statute. A business trust has been held not to be subject to a tax on all moneyed or stock corporations deriving an income or profit from their capital or otherwise, or to a tax imposed upon the capital stock of all companies incorporated by or under the law of the state or incorporated by any other state and doing business in the taxing state. However, the definition of the term corporation in the taxing statute may be so framed as to include business trusts. Thus, a business trust has been held subject to state income tax as a corporation rather than as an individual, where the statute defined corporations as including associations and the Constitution defined corporations as including all associations having any power or privileges not possessed by individuals. Section 85. Franchise or excise tax. A statute imposing a franchise tax on corporations and defining the term corporations as including any business conducted by trustees wherein interest or ownership is evidenced by certificates or other written instruments is not unconstitutional. So too, a state legislature has been deemed to have the power to impose a tax upon business trusts, as such, for the privilege of doing business within the state, and to provide that such tax shall be measured by the net income of the trust. On the other hand, since a business trust has its origin in the common law right of the parties to enter into a contract and does not spring from a franchise granted by the state, it has been held that constitutional authority to levy excises upon commodities, a term including corporate franchises, does not empower the legislature to impose an excise tax upon business trusts measured by the value of the shares. Sales taxes duly levied against the trust. 86. Taxation of shares or dividends. The shares in a business trust have been held not to be taxable as stocks in a moneyed corporation. A state cannot, under the Due Process Clause of the 14th Amendment, tax as investments or intangible property of a resident of the state transferable certificates of beneficial interest under a declaration of trust entitling the holder to a proportionate share of the rents derived from specified parcels of real estate in other states and to a share in the proceeds of any sale of the property. A certificate of shares in a business trust organized in another state, the REIS of which consisted of real property located in the other state, has been held not to be a security, subject to an intangible personal property tax, but rather a muniment of title to an equitable interest in the trust property, and therefore not taxable. And where a business trust was formed to deal in mineral lands and leases, with absolute control vested in the trustee, and the holders of the trust certificates were entitled merely to receive such profits as were paid to them, unaffected by any such relation as that of partnership or joint stock associations, it was held that the individual interests of the beneficiaries were not subject to taxation under a statute providing that all properties, whether real or personal, in the state, and all monies, credits, investments and bonds, stocks, joint stock companies, or otherwise, should be subject to taxation. However, Dividends from a business trust have been held taxable under a state income tax statute, providing that the term dividends should mean all dividends derived from stocks, whether paid to its shareholders in cash or in property of the corporation, and defining corporations as including corporations, joint stock companies, associations or common law trusts organized or conducted for profit. Inheritance, estate, and succession taxes on shares in business trusts are treated in another article. B. Federal taxes. Section 87. Generally, a large amount of litigation has arisen, under the provision of the Federal Revenue Acts, that the term corporations includes associations, joint stock companies, and insurance companies, involving the question of what constitutes an association within the meaning thereof. This inquiry usually arises in connection with the question whether an association is subject to federal income taxation on the same basis as a corporation, in view of the definition of a corporation, for the purposes of the Internal Revenue Code, as including associations, joint stock companies, and insurance companies. Business trusts are generally taxable under the Internal Revenue Code, being usually included in the term association, for the purposes of federal taxation, and being specifically mentioned in the Treasury regulations as included, where they are created for the purpose of engaging in business for profit. Yet there are instances where trusts which come literally within the usual definitions of business trusts have been held not to constitute associations, for the purposes of these acts. The nature of a business trust for this purpose is determined by different tests from those applicable in other situations. A finding by the Board of Tax Appeals that a trust is not engaged in business in such a manner as to be an association within the Revenue Acts has been held not to be conclusive on appeal. Sums paid by trustees of a business trust to a state as income taxes on dividends paid by the trust to shareholders in the state, pursuant to a trust instrument providing for the payment of taxes on dividends out of the surplus or net profit of the trust, are not deductible by the trust as ordinary and necessary business expenses, in computing its federal income tax, where the trust was under no obligation to make the payments except out of earnings or profits. An act of Congress imposing a stamp tax upon the issuance of certificates of stock of an association, company, or corporation, has been held to apply to certificates of shares issued by a Massachusetts trust organized to engage in the business of manufacturing textiles, and the federal stamp tax was held to be payable on a conveyance made by trustees of a business trust to a new trust formed as a part of a consolidation. Section 88. Tests for determining whether trust is association. Various tests have been applied by the courts in determining whether a business trust is an association subject to federal taxes under the Internal Revenue Code. The most important single element to be considered in this respect is whether the enterprise is created for the transaction of business. All the other criteria are subordinate to this primary and paramount test. The substance of the distinction between a non-taxable trust and a business trust which is taxable as an association lies in the intrinsic nature of the enterprise and the relation of the several associates thereto, rather than in the mere form of the association or in technical distinctions between corporations, partnerships, and the like. It is now settled that the degree of control which the beneficiaries of a trust may exercise over the trustees or over the business or property of the trust is not determinative, and that a business trust may be an association although the trustees are free from the control of the beneficiaries. Neither is mere size important in determining whether a trust is an association, taxable as a corporation under the Revenue Acts. Indeed, it has been held that a trust may be an association under the statute, even though the certificates of the beneficial interest are held by only one person, or there is only one trustee. The fact that the trust is engaged in a single enterprise or a limited number of operations does not necessarily prevent its being classed as an association within the statute. The status of a trust under the laws of the state in which it operates does not determine whether or not it is an association, for the purpose of the Revenue Acts. The term association, as used in the Revenue Act, does not require organization under a statute and is not limited to trusts having statutory privileges. The fact that at the time the trust was organized the trustee did not know who would become shareholders does not exclude a business trust from the operation of the statute on the theory that in such a case there were no associates. Whether or not a trust amounts to an association, within the meaning of the Federal Revenue Acts, depends, in the final analysis, upon the facts and circumstances of each individual case. Section 89. Business test. The most important single element to be considered in determining whether a trust is an association, so as to be taxable as a corporation under the Internal Revenue Code, is whether the enterprise is created for the transaction of business. All the other criteria are subordinate to this primary and paramount test. The test is whether the trust is a business concern, and whether the shareholders or trustees, or both, are operating it in active business for profit. Generally, only those trusts are taxed as associations which are engaged in doing business for profit or income. The word business, as used in this connection, connotes a commercial or industrial establishment or enterprise, as distinguished from property, and means the activity, the energy, the capacity, and the opportunities by which results are reached. A trust is not deemed to be engaged in business, within the meaning of this test, if its sole or principal object and activities are 1. The preservation of specified property, 2. The liquidation of a trust estate, or 3. Distribution of income derived from another source. The mere receipt of income by the trustee from trust property and the payment of charges and expenses does not constitute such business as will characterize a trust as an association. The type of organizations not intended to be included in the term associations for federal tax purposes are pure trusts, that is, trusts of traditional pattern under which property is conveyed by deed, will, or declaration for the benefit of named or described persons. In determining whether a particular trust is a business trust, and hence taxable as an association, its resemblance, in its powers and purposes, to a pure trust is relevant, but the mere presence of one or more of the elements usually attending a pure trust does not ipso facto characterize it as a pure trust, since some of the characteristics of such a trust may be adapted, under some circumstances, to a business purpose, as distinguished from a trust purpose. Section 90. Corporate similitude, use of corporate forms or procedures. The inclusion of associations in the definition of the term corporation as used in the Internal Revenue Code implies some resemblance between the two, but it is resemblance and not identity which is contemplated, and definitions are not to be pressed so far as to make formal procedure a controlling test. While use of corporate forms may furnish persuasive evidence of the existence of an association, the absence of particular forms, or of the usual terminology of corporations, is not decisive. The question of the taxability of a trust as an association does not turn merely upon technical differences between the trust and a corporation in respect of their organizational structures. The determinant is rather the approximation of corporate advantages by the use of a trust instead of a corporation. It has been said regarding the corporate analogy that there should be a balancing of resemblances and contrasts, and effect given to the dominant functions and attributes of the organization. In determining whether a trust amounts to an association, within the meaning of the Federal Revenue Acts, it is unimportant, or at least it is not controlling, that meetings are not held by the beneficiaries and that the trust has no office, place of business, seal, bylaws, or official name, or that there are no formal meetings of trustees or directors, or that their organization is of a loose and informal character. The test of an association is not to be found in the mere form of the evidence or certificates of interest, or in any particular method of transfer, and it is unimportant that no formal certificates of ownership were issued. The name given to the evidences of interest or to the beneficiaries is unimportant. Limitation of the beneficiary's liability is not a sine qua non of the corporate analogy, and the absence of such limitation does not necessarily preclude the status of association. And as continuity of organization is an attribute of trusts as well as of corporations, this feature is not sufficient in itself to characterize a trust as an association. The same is true of the existence of the right to transfer beneficial interests. Section 91. Terms of trust instrument, or activities of trustees. Although there is authority to the contrary in some of the earlier lower court decisions on the subject, the Supreme Court of the United States has ruled that the character of a trust as an association for federal tax purposes is governed by the terms of the trust instrument, since the powers of the trustees can be exercised by them to the full extent therein permitted, and that for the purpose of avoiding taxation as an association the parties are not at liberty to say that their purpose was other or narrower than that which they formally set forth in the instrument under which their activities were conducted. In other words, whether there is an association for the purpose of carrying on a business is to be determined from the trust instrument itself, from what could be done under the trust and not from what was actually done, or what the parties to the instrument thought they could do. The legal effect of the instrument is controlling as against the direct affirmations, disavowals, or protestations embodied in the instrument. So, The fact that the organization in question has consistently called itself a trust is of little or no significance in determining its true character under the Revenue Acts. Moreover, where a trust has the characteristics as well as the powers of a business trust, it cannot escape taxation by the failure to exercise such powers during the taxing period, or by declining to exercise them, since the trustees could, if they choose, exercise them. On the other hand, a consideration of what the trustees actually do is not necessarily inconsistent with the foregoing principles. The actual activities of Section 90. Corporate similitude, use of corporate forms or procedures. The inclusion of associations in the definition of the term corporation as used in the Internal Revenue Code implies some resemblance between the two, but it is resemblance and not identity which is contemplated, and definitions are not to be pressed so far as to make formal procedure a controlling test. While use of corporate forms may furnish persuasive evidence of the existence of an association, the absence of particular forms, or of the usual terminology of corporations, is not decisive. The question of the taxability warrant, bring an action in equity to procure its dissolution. A court of equity may, on a proper showing, decree the dissolution liquidation of a business trust, prior to the time specified in the trust instrument for its termination. A minority shareholder cannot, arbitrarily and without equitable grounds, demand the dissolution of the trust contrary to the terms of the trust instrument and before the objects of the trust have been accomplished. Nor may a shareholder in a business trust, even though in legal contemplation it is regarded as a partnership, assert a partner's arbitrary right of dissolution to obtain a dissolution of the trust during its lifetime in a manner different from that provided for in the trust instrument. And it has been held that a person who did not join in the trust agreement is not entitled to a decree setting aside or declaring void the agreement where to do so would result in injury to all of the parties. But, where a business trust falls within the constitutional definition of a corporation, the right of the state to terminate its activities for failure to comply with statutes regulating corporations has been recognized. As a general rule, and unless the trust instrument so provides, the death of one or more shareholders of a business trust does not have the effect of dissolving or terminating the organization. Nor will the acquisition of all of the shares of a Massachusetts trustee by another such trust terminate or destroy the separate existence of the former trust. The conveyance of the trust property by the trustees does not terminate their trusteeship with respect to duties remaining after such conveyance, and the sale of the property of a business trust in foreclosure proceedings does not amount to a dissolution of the trust where a trustee purchases the property at the sale under such circumstances that it inured to the benefit of the original shareholders, especially where the business trust remains thereafter in charge of a receiver appointed by a court. Frequently, the trust instrument provides that upon the expiration of the term of the trust the trustees shall wind up the affairs of the trust, liquidate its assets, and distribute the proceeds among the shareholders. Where the trustees are given the power to terminate the trust at their discretion by dividing the trust fund among the shareholders, it has been held that they may not terminate it in another fashion. Upon the termination of the trust, the functions and powers of the trustees as such come to an end, except for the purpose of winding up the business and distributing the remaining assets among the shareholders. Section 93. Grounds for, and circumstances warranting, equitable action and relief. Although a court of general equity jurisdiction has the power to decree the termination of a business trust on the ground that it has expired by the terms of the trust instrument, a court of equity will not decree the final dissolution of a business trust, contrary to the terms of the trust instrument, without a very clear showing of necessity. It has been held that a court has no power to dissolve such a trust in violation of the provisions of the trust instrument, in the absence of a showing that the business of the trust cannot be continued. And the right of minority shareholders to maintain such an action, in the absence of provisions of the trust instrument giving them that right, has been said to depend upon a showing that the purposes of the trust are no longer capable of fulfillment under proper management or that the business could not be continued as contemplated by the trust instrument. The facts that the trustees of a business trust are not pursuing the purposes of the trust and that they have paid no dividends to the shareholders, while perhaps proper to be considered in a proceeding to remove the trustees, are not a ground on which shareholders may maintain an action to dissolve the trust, in the absence of a showing that the trust could not be continued under proper management. And the mere fact that a subscriber purchased shares under the belief that the officers and many of the other subscribers were in favor of closing out the affairs of the trust does not entitle him to a dissolution of the trust, without other grounds and prior to the accomplishment of the purposes of the trust. On the other hand, It has been held that a court of equity has inherent power to appoint a receiver to liquidate a business trust where fraud, mismanagement, or abuse of trust is present, whether or not insolvency is likewise present. A hopeless deadlock in the management of a trust, paralyzing its business and activities, may warrant a court in dissolving the trust before the expiration of its term. And the facts that the parties to a trust agreement organized the trust and became shareholders under the mistaken belief that a provision of the trust instrument, expressly purporting to do so, was effectual to exempt them from personal liability for the debts of the trust, and that by subsequent judicial decisions the law was established that such shareholders were personally liable notwithstanding such provisions, were held grounds for the dissolution of the trust at the suit of the shareholders. Liquidation of a temporarily solvent business trust has been held proper where the capital structure of the trust, although not subject to the controls of federal legislation governing investment companies, but failing to comply with standards and safeguards prescribed therein, would permit controlling shareholders to launch the trust upon speculative enterprises making future insolvency likely and threatening the rights of debenture holders, and where the controlling shareholders and the Securities and Exchange Commission were unable to agree upon an acceptable plan for reorganization of the trust. Section 94. Scope of equitable relief. Where a court of equity has once assumed jurisdiction of an action to dissolve a business trust, it may adjust all the rights between the parties, and will retain jurisdiction until that end is accomplished. In a representative suit to terminate a trust, the court may require an accounting by the trustees, may enjoin the prosecution of other suits affecting the trust to avoid multiplicity of action, and may partition the property of the trust among the parties. Section 95. Receivership. The general equitable principles permitting the appointment of a receiver by a court of equity when conditions warrant such action apply to business trusts. Whether a receiver for a business trust will or will not be appointed ordinarily rests in the sound discretion of the trial court. Such court may, where the conservation of the trust property and the successful management of its business require it, appoint a receiver to operate the business of the trust. The facts that such a trust is insolvent, and that, unless prevented, the trustees will dissipate the assets of the trust estate, constitute a ground for the appointment of a receiver for the trust. Where a business trust is being mismanaged or is in danger of being lost to the shareholders through fraud, collusion, or mismanagement on the part of the trustees, the court of equity has inherent power to appoint a receiver to take charge of the property and assets of the trust to prevent loss to the shareholders. Where no substantial rights will be unduly infringed thereby, it is within the discretion of the trial court to appoint a temporary receiver pending an action by shareholders against the trustees of a business trust for an accounting, or as an incident to injunctive relief sought by shareholders against the trustees, where the receivership is necessary to render the injunction effective. But shareholders are not entitled to the appointment of a receiver for the trust as an ancillary process to aid them in the collection of an alleged individual debt of the trustees to them. Generally, the receiver of a business trust takes its assets subject to the equities which existed as against the trust. The rule applicable to public service corporations, with respect to priorities of claims for current supplies, was held to be applicable in a receivership involving a business trust which carried on a public service business. The termination of a receivership also lies within the judicial discretion of the court, in the exercise of which the court will consider the rights and interests of all. A court of equity in terminating receivership of a business trust has inherent power to order such measures as are necessary or proper to see that the property of the trust is turned over to one legally entitled thereto. Hence the court may, in its discretion, order the shareholders to be notified of a motion to terminate the receivership, and give them an opportunity to be heard thereon. Section 96. Reorganization or merger, generally. There may be a merger of several business trusts, which may be effected by implication from the manner in which the businesses of the several trusts are conducted. And the doctrine of estoppel has been invoked against a business trust seeking to stand upon a separate legal identity from that of an organization to whose business it succeeded. However, it has been held that the trustees of one business trust cannot, by any partnership arrangement with another trust, divest themselves of their personal duty to manage and control the trust estate confided to their care. The trustees may, where the trust agreement authorizes it, create a subsidiary or auxiliary trust. Bankruptcy reorganizations of business trusts are treated in the article on bankruptcy. Section 97. Incorporation, merger with, or transfer to, corporation. Where the terms of the trust instrument authorized it, A business trust may be reorganized by the creation of a corporation, the conveyance of the trust property to the corporation, and the distribution of the corporate shares among the shareholders of the trust according to their respective interests. In the absence of a provision to the trust instrument expressly authorizing the transfer of the trust estate to a corporation, the power to do so may be found in general provisions empowering the trustees to convey the trust property or to terminate the trust and liquidate its assets. However, the trustees will be enjoined from carrying out a plan for the reorganization of the business in the form of a corporation, where the powers and objects of the corporation are substantially broader than the objects of the trust and the power of the trustees thereunder. It has been said that no court has jurisdiction simply to rewrite a contract at the behest of dissident parties, or to convert their trust indenture into a corporation in the absence of practically unanimous consent. It has been held that a corporation organized to take over the business and property of a business trust, and to which the property of the trust was conveyed, takes such property subject to the rights and claims of the creditors of the trust, and that a creditor of a business trust may maintain an action for discovery to determine what assets have been transferred by the trust to a corporation organized by those interested in the trust.